Thank you very much, ladies and gentlemen. Just recapping on the first part of this morning's session, the question of contacting the mediator. I was speaking to Simon Fraser from Lander and Rogers just during the break. And my own experience, and I know other mediators do this, is when I'm contacted by another barrister, I tend to make a note of the conversation because I think it's very, very important, like in any process, that the process be impartial, independent, and there be no element of unintendedly of contaminating the process or poisoning the process. So I think as a mediator, if you're contacted, my tip to you would be listen, make a note, and Travis agrees with this. And I would also, at the beginning of the mediation, inform the other lawyers that you've had this conversation with the other barrister or solicitor and what the contents of the conversation were. Generally, barristers and solicitors, when they do approach you, as Travis said, it's to outline what the legal issues in the dispute are, which are evidently clear on papers. But I certainly would make a note and inform the other side. Simon, do you agree with that approach? You've had extensive personal injury experience and dealing with statutory organisations. What's your view?
Yes, I agree with that approach, although personally I don't tend not to contact the mediator beforehand. I'll leave it to the day of the mediation. But as you say, it's important that in case there may be a sharp practitioner who seeks to take advantage of an exchange with the mediator that the other party is not privy to, and that's to be avoided.
Yes.
And that's why I think if you are going to contact the mediator beforehand, give a plain vanilla cast of what the dispute is. Don't try and influence the mediator's mind. It doesn't really help you anyway because they're not judging the case. But you can expect that whatever you have said to the mediator may be relayed in the joint session at the start. So you need to be careful what you do say.
And I agree with you, Simon, the approach you take, because I think the mediation should start when the mediation starts, and I don't want to get involved in any in-depth discussions, and certainly not in relation to what's going to happen at the mediation prior to that at all. You can at least, you can talk about what would be helpful for the party to send you, or for the practitioner to send you, and to identify certain things, but providing you've got the papers, whether it's the pleadings and or the points in dot point form that are going to be relied on as part of the case of each party, I think most of it can wait till the mediation. And I agree with that approach.
Yes, sir. Brett, could you pass the microphone to the gentleman? Thank you.
Come back, Brett. Oh.
Sorry, just backing that. I've been doing in practice for well over 20 years, and I was in mediations for a lot of that time. And one thing I've noticed over the years is that often the pleadings don't give a real indication. I think a number of you have mentioned they don't often give a full indication or even a realistic indication of what the issues are, and certainly often by the time you've got to the mediation there are other issues that are through the discovery process and what have you. So when I make a point generally of contacting the mediator at the outset to do what Travis said, to outline them. And but the other thing is that often especially if you've got experienced practitioners, you know the mediators, you tend to use mediators that you know and know how they respond in different situations, and when you contact them to see if they're available, that's when I outline what the issues are, because I want to make sure that they're going to be able to get a grasp of the issues. So it's not a matter of influencing, but it's making sure that the mediator you have in mind is going to be able to get a hold of the issues and understand them. And that's particularly so where in many cases mediators don't necessarily ask for position statements beforehand. So if they're just relying on the court documents, particularly the pleadings, often, particularly if it's defence, where you might have certainly in the old days where you'd often have just a basic denial or non-admission. Now these days obviously you have to go a bit beyond that, but they're still not often very illuminative of what the real issues are. So I think it's actually important that the mediator is made aware of that, rather than get to the mediation and still not be too wise as to what's involved.
Because at the end of the day, we all want a hard-working mediator whose sole purpose is to assist the parties to mould a settlement. I mean, that's what they're employed to do, and that's what they should be doing. We don't want them sitting back passively. We don't want them giving legal advice, as Michael says, but we don't want them sitting back passively and having an easy day, which I think, sir, covers the point of the client. At the end of the day, it's the clients that are in the mediation. And I think there's a whole piece as part of the mediation process around client management, how you manage a client, how a mediator manages a client, how the barrister and solicitor manage a client in the mediation process. Now, we're very lucky today in that Gerald has been a client in a number of mediations. And I have been an expert in a mediation. I've been a barrister and I've been a mediator, but I've never been a client, and I hope I never am a client in a mediation. In your experience in being a client, Gerald, what tips would you give us in managing clients having sat on the other side of the fence?
I think it's an educative process at the mediation stage, because the client is cost sensitive, and we're talking about preparation without talking about the cost effectiveness. I think that's one of the things that's extremely important to the client. But it's not going to come naturally to me as a party to know that what the investment in the mediation phase might bring. I would have already invested a fair amount of costs, and obviously you're going to invest a heck of a lot more in the trial. So I need to know where the value is in this, and I'm only going to get that value if I'm coached, if I'm prepared, and if my lawyers are also pressing the other side to get engaged. One of the most soul-destroying experiences in mediation is when someone is coming along on the basis, and perhaps their advisors have put it to them on this basis, we'll just get to the mediation and see what we can get. And you get a passive sense in there, and sometimes that can affect the mediator as well. As a party, I want to see some activity, but particularly before I get there and while I'm there, I want to revise what the optimal, suboptimal, what a good outcome or a poor outcome or a really damaging outcome could look like. And that means that you as my advisor have got to go through with me not just the legal and factual issues, but also the possible range, perhaps 4 potential outcomes from a cost and success or lack of success point of view. And I would need that revised during the time of the mediation. Then I'm starting to get an idea of what the risks are that I should be thinking about, and it will educate me from my views, personal views perhaps, as to what should be the resolution, as to what an opportunity I have to craft some form of solution that's going to stick, that's going to be possibly more suitable than the range of remedies available to the court. Very much a coaching process required from you as legal advisors to me as the party in that preparation phase.
And I wasn't aware that Gerald also has a psychology degree, and I think Barry and Ross talked about this, having empathy with the clients, the mediator having empathy with the individuals who are hemorrhaging commercially, who are hemorrhaging in terms of their domestic relationships, who have severe community or environmental issues. And I think it's very, very important to listen, understand, and actually listen, not pretend to listen, but really listen and have empathy with the conflict and the dispute that these poor people have that are before you as a barrister, solicitor, or as a mediator. How do you handle clients these days, Travis, being of the younger generation?
Well, what Gerald's just said, I think, is at the core of it. For me, the client needs to understand the range of outcomes, and that's got to be the first step in approaching a mediation. I like to try and find out from the client whether there's any other options. You might have the four walls of a dispute on the pleadings, but I think full preparation lets you see if there are any other options that are outside that can be brought into the equation, because sometimes you can resolve a dispute by bringing something else in which the other party didn't think was an issue and didn't really care about. Your client felt that they desperately needed that, and all of a sudden there was ground given on the centre of the dispute. So I like to find out the broader context that the client sits in, and also because your client is the only person probably who's had direct dealings with the other party. They're going to know them better than you ever possibly will. So you can find out from your client what's driving the other side. Again, that can help identify areas that you need to try and work on in the dispute. And I think finally for me, the one thing that I've found to be really useful, and I've had feedback from clients that it has been useful, is because it's often said that mediation is a process, or a successful mediation is a process that both parties walk away from equally unhappy. I tell my clients that, and I tell them, look, you are going to make decisions in the course of the mediation. I tell them this ahead of the mediation, as long as I've been given the brief in time. But you're going to make decisions, and it's very likely that in the days or the weeks after the mediation, you'll replay the mediation and you'll think, oh, maybe if I'd just done that differently, or maybe if I'd just said no here, I could have got more money, or I could have got this different. And that's a common thing. And I've had clients who've said to me, after I've explained that to them, they've settled, they've gone away, they've had the second thoughts, but having been forewarned about the possibility that that would happen, they've come back and said, I did have the second thoughts, but because I knew that I should be expecting them, it didn't trouble me, and I've put it all behind me and I've moved on. Now, one thing I will clarify there is, of course you have to be extremely careful that when your client's making a decision at mediation, that's a decision they're comfortable with. You have to be at pains to make sure they understand the offer they're making or accepting, and not to put any pressure on them. And as soon as they feel under pressure, you've got to back away.
But taking up on that point, though, about clients going away equally unhappy, they won't be nearly as unhappy as they will be if the matter proceeds to court. Apart from the effects upon their pocket, one of the clients is going to be bitterly disappointed because there's got to be a loser, and you always point that out. And apart from the fact that, as we know, say if it was going down to VCAT, for example, even the victor down there is well and truly out of pocket. So there's no winners to that, and you point that out. But it is a question of sensitivity. The Victorian Bar, through our Dispute Resolution Committee, ran its first mediation course for some 20 years, back late last year in October, and we had a number of candidates, barristers, a judge and a number of solicitors, and I was one of the coaches doing the assessing as well as the coaching over a 2-day period, and it was extremely successful. And we repeated the dose at the beginning of May of this year, and we're going to do it again in July and November. And during the course of those courses, which I've been involved with, one of the things that I certainly do emphasise is the question of sensitivity, and to try and read the play as best you can. And sometimes, and it doesn't hurt, to introduce some humour. I mean, not inappropriately, I hope, but there are occasions in which you can introduce humour to break the ice and get people feeling a bit good about themselves, and all those sort of little things all add up at the end of the day to a successful mediation. And I can't overemphasise that. As far as the actual conduct of the mediation in the introductory stages is concerned, I'd like to say something about that, but maybe a bit later, Georgina. Or
yes. Brett's got a question from the floor.
Sure.
I'm really referring to the question of, or the issue of position papers, which was raised a short time ago. I'd like to know what the panel and members of this meeting think about that issue. I sat as a mediator, or when I sit as a mediator, or when I attend as a lawyer, I think that position papers are more important than the pleadings. At least I think they should be treated as being more important than the pleadings. And I think an issue that arises, and I'd like to hear comment on it, is the need for candour in the preparation of those, and the need sometimes to preserve your powder for the trial, but how you manage that in articulating or advocating for your client, and what the mediator's role should be in dealing with the position papers if the mediator is of the view, which may well be well-founded, that the powder is being kept dry.
Can I just take that up? Yeah, I totally agree with you in relation to that very good point that you just raised. I think position papers are far more important than the pleadings, and because they should really take you to the crux of what it's all about, and that's incredibly important. And in the introductory stages to a mediation, apart from explaining the procedures and what a mediation's all about and the question of confidentiality so that people can let themselves speak freely without fear of being brought up at a later stage, the other thing that you emphasise, and you should emphasise to parties, is the fact that it's essential that both parties, or there's more than one, two or three or four parties, act in good faith. And in other words, they act in a spirit of conciliation in terms of being willing to make concessions and to listen to what the other side has to say and all the rest of it. And that all gets its trigger or start from the position papers. And if of course, the parties aren't prepared to act in good faith, as I say, at a very early stage in the introductory phase of the mediation, well then the mediation's just not going to work. We might as well all pack up and go home, because mediation being of a voluntary settlement, it's just it's critical that parties act in good faith. If they don't, well, it's not going to work. But I totally agree that it's the position papers that are important, combined with, of course, the opening statements as to what the issues really are.
I have a slightly contrary view to that, Rob. I think I welcome position papers. I prepare for them often as a barrister, but I don't think they're always necessary. I think if a barrister is well prepared, if a mediator is well prepared, you can work out the issues very quickly, and you are also attuned to what you're not being told. Because there's many stages of the mediation process where a mediator will start considering what they're not being told and what underlying issues are there and how they all gel into the general dispute and the conflict that the parties have. So, yes, they're helpful, but I know as a barrister that when I'm preparing a position paper, there's a lot of information which I won't put in there. I will want to keep my powder dry, and I'll want to stay mute on a number of issues to ensure that the merits of my client's case is always protected, whilst at the same time moulding a settlement in the best interests of my client, but knowing in the back of my mind that if there is the 5% chance it may not settle at the mediation, I've got to preserve something for trial. What's your view, Gerald?
Well, I'm going to take the view of the party, which is if I don't understand the position paper that you've prepared for me, then I haven't been prepared properly, and I'm not going to come to this mediation in a problem-solving frame of mind. And I'm going to go back from there to say that whatever is in the position paper is really the argy-bargy between the lawyers at the legal level. If you want the mediation to work, in my view, the client has to be able to say what in your own discussion with your client, what the legal issues are, what the factual issues are, and articulate what it is they want, and articulate what the risks are. And you mentioned before, the commercial outcomes that might be unsatisfactory if they go to trial. That's exactly what I think a client needs to know all the way through. And in that analysis with the client as to what the range of potential outcomes might look like, let's not forget to tell them about the appeal. Out of the times I've been a party, I've had 3 successful judgments. It's given me the privilege of being cross-examined 3 times, and then had 3 appeals, one completely successful, one a 50-50, and one a complete loss. And that risk has to come into that risk analysis with the client as well, so that they can see your problem-solving demeanour, you're modelling a problem-solving behaviour. They take it on themselves. It lifts the standard of the mediation, because the mediator, I think, then gets more engaged when we talk about being sensitive to the various parties, and it lifts, hopefully, the clients out of the mindset of sitting there just thinking dollars, just thinking I've got to report to my CEO at the end of the quarter, and I don't want to report less than X amount. It's really about coaching.
But the only thing I don't agree with Georgina about, I don't believe in saving something for the trial. Of course, you've got that in the background as the alternative, and I mean that should be made very clear to the parties. And whilst position papers, I welcome them very much, but of course they don't take the place of the opening statements, particularly by lawyers, whether they're barristers or solicitors, it doesn't matter. But the mediation is a process that really runs on its own, and it's a process that aims to try and resolve the dispute, and you shouldn't be holding back in relation to what might happen at litigation. It's very of course the litigation alternative is always there in the background. You warn them about that at the start by reason of the cost involved, and that's and not just the cost, but the angst and all the rest of it. But the mediation is something on its own and should be approached as the it's it in the bit, if you like, to try and get this dispute resolved.
Got a question across here, Brett. Gentleman in the front row. Thank you.
My main area of involvement in mediation has been as a family lawyer, and I'm not sure whether this is a problem that we exclusively find in family law, but I understand and hear everything you say about management of clients, but often our main problem is, say, a practitioner on the other side that might be overly invested in the case, giving advice that may be outside the range, and in fact that's often an impediment to reaching a settlement. Now, as a participant or as a representative in the process or as a mediator, how do you handle that?
That is a really hard call. I thank you for that question, because all of us in the audience have grappled with an opponent of that description. I think having a very good general session where all the issues that the panel and the audience have outlined is the way of getting around that person. You can't, all the psychologists will tell you, you can't go bull at a gate at a person, you've got to go around them. So I think an effective general session is crucial. Now, what I mean by an effective general session is you tell the clients what the present and future costs will be in detail. You don't just give them a cursory view, you set it out in black and white. Your current costs are X, your future preparation costs are Y, the trial will take X, interlocutory application, you break it all up. It's crucial to do that in the general session. Crucial to have really good opening statements by the barristers, and sometimes if a barrister or solicitor is a bit short because for whatever reason, ask them a few questions, clarify the issues, clarify the facts, and you can do it in a very polite, diplomatic manner. You have to interrupt them, but you just do it politely. I think another way is to ask clients, and you've got to be careful how you phrase the question during the general session. How do they see the process occurring today? Because if you can engage with a client in the general session, and you've got to pick your client, then you're hearing what the client's opinion is, whilst their solicitor or barrister is next to them. I think that's, in certain, again, horses for courses, but in certain instances that is a really good tactic to use. I think pulling the barristers aside or the solicitors aside is a good thing, and ultimately I've pulled individuals aside and said, look, I'm really concerned where this is going. We now have the Civil Procedure Act, which means that we all have overarching purposes and overarching obligations, and on a one-on-one basis, I have told individuals to pull their heads in privately because I have the Act now that assists us all. We have this wonderful piece of legislation which says that we all have this overarching purpose and obligation to efficiently and justly, in a cost-proportionate manner, resolve civil disputes in our service industry. So that's how, but that is a really hard call, and you've got to have empathy, and you've got to listen, and you've got to understand the nuances and the underplay that's occurring, because it might be a situation where that lawyer is doing a whole lot of other work for that particular client and wants to impress, understandably. So there might be a whole lot of other factors that you're not aware of. Travis, how would you do it?
Yeah, I think one of the, this is the perfect example where the mediator can be your friend, and picking a good mediator is essential because the mediator is the only person who is going to get in the room with the client and the lawyer who's got views that come from Mars. So you pick somebody who is going to impress the client, potentially, or is going to be able to make the client or assist the client to see reason. Now, Michael's going to disagree with me, I'm sure, and so that's not the mediator's role. But we know there are mediators who do this, and whether it's their role or not, you can get a mediator who will do this. And if you can get somebody who you think may be a good cross-examiner and may be able to sit down with that client and say, well, have you thought about this, or what about that? And it might not be giving legal advice, it might be asking pointed questions. And that way they might start to doubt the advice they're being given, and it might mean that their representatives also have to start to rein that in a little bit, and then you get them to start to see reason. And they're the mediations that take an awful lot longer than the ones where you've got sensible people on both sides, but they are possible to turn people around if you use the right factors, including all the ones that Georgina's just said.
But I think you must have misunderstood what I said, though. What I really said is that you don't get into the advisory stage, but however, particularly with an unrepresented party, of course you'd like them to think that you're their friend, and you are, to the extent that you're helping them to the best of your ability, and they might be being outgunned by a better resourced opponent and all the rest of it, to help them to reach a resolution, and they soon get that message from just the approach you take towards them and your demeanour and all the other things, your smiles or whatever it might be, and of course you like them to think that you're friend and you're their friend, and to help and assist in a resolution in that way. And I've often had that experience and saved a mediation that looked like it was totally on the rocks.
Michael, can I just ask you, from the party's point of view, and I think at times from the solicitor's point of view, there's a lack of certainty about what you hear in the mediation is without prejudice, but there is likely at some time for the party to want to speak and not know whether what they say, even in confidentiality terms of the agreement, may be revisited outside of the mediation. Sure. What's the risk there and what's the controls? Right.
Well, you explain to them the confidentiality aspect of a mediation, which basically is based on the without prejudice privilege, which all legal practitioners are aware of, and you explain to them that that arises primarily from the contract itself, which is the mediation agreement, that all matters conducted within the context of the mediation are confidential, and they are protected both at common law and by various pieces of legislation. I don't want to spend half the mediation going through a paper I've written on, or co-authored I should say, on the subject of confidentiality, but you can say, well look, there are some exceptions, and deal with questions of waiver if you want to, or enforcement purposes, or fraud or criminality, public safety, but you really don't want to get the mediation bogged down into that. And you just say, well, essentially you should feel free and very happy and able to put your best foot forward and to say whatever you like without the fear that when this mediation unfortunately fails, and I'll say I'll be trying to do my level best to make sure it doesn't, but if it does fail, that when we get to court, or when you get to court, that it can be brought up against you. And it's in that context of talking about that's at the initial stages, before, as I explained before, you start off in that general session discussion between the parties, but you even go a bit further when you get to the private sessions, because you make it very clear that's whatever's said to you by a party in a private session, either whether they're represented or otherwise, that whatever they tell you, so they've got full confidence in what you're, in you as a person, apart from as a mediator, that you will not disclose what's said without their express permission. And of course, that's what that's the extension of the confidentiality into the private sessions. But there are certain aspects of legislation, such as Section 131 of the Commonwealth Evidence Act, which in some parts is too wide as far as exceptions to confidentiality. But of course, as you can appreciate, when you get to the stage of a mediation agreement itself, the fact that there is an agreement has to be disclosed ultimately if it needs to be enforced by a court. But confidentiality is the very essence of a mediation, together with what I've said before, the parties acting in good faith. And I've myself and the great Tony and Owen have co-authored a paper on confidentiality in mediations, and I'd invite anyone here present, if you'd like to read that, before leaving today, just give me your email address and I'll arrange for my secretary to send you a copy of the paper. It deals with all aspects of confidentiality, and if I do say so myself, primarily due to Tony, not me, it's not a bad paper, so it might be worth reading.
And I think this topic of documentation is probably towards the later stage of the mediation process. It is important when you have what I call supporters of litigants in a mediation to ensure that they sign the mediator's confidentiality clause, confirming and understanding that they're there to support the litigant, whether they be a co-business partner, whether they be a relation, and they understand that confidentiality applies to them also, not litigants, but the confidentiality of the whole mediation process applies to them. So I agree with Michael, it is very, very important to ensure that they're signed up. The other thing that I think is very important, it's a question I'm going to ask Travis to comment on, is documenting a settlement. We have been conducting mediations now for in excess of 20 years. It's become part of our profession. Most of us now go to mediation with draft terms of settlement, draft release, USB sticks, and have some idea of what the formula of resolution will be in a dispute, whether it be a new transaction, whether it be a wash-up of family law assets, whether it be a sale of a property and a division by way of percentages. You've all got some idea, if you've properly prepared your clients and your mediator, when you start the mediation, what sort of formula of resolution will be reached, whether it be formula of resolution A, B or C, because that's how you're working towards moulding a settlement for your clients. So Travis, how important is it to document the settlement, and do you not leave a mediation until it's documented?
I think those questions really answer themselves. If you leave it, there is only one case that I can remember where I've ever suggested leaving a mediation before there was a documented settlement. It managed to stick together, and the exceptional circumstances were there were 8 separate parties involved. My client had psychological issues and was starting to break down under the pressure of the mediation. So I got all the other parties to sign up to the document and leave it open for 7 days. Took my client away, said, take a couple of days off, think about it, come back, take our advice, and then if you're still in a position to do it, sign the terms. And thankfully they did, because it was in their best interest. But as a rule, if you leave a mediation before the document's signed, you're just asking for trouble. So yes, take along a draft, have an idea, the terms on which it might settle. If you've got an iPad or a laptop, you can bring along. Usually somebody will give you access to a printer, or you can duck back to chambers or whatever it is. But you've got the general terms ready to go, and you don't have to think about drafting on the run. And it saves, you know, the drafting process can take 2 hours at the end of a mediation when everybody thinks the deal's been done. But if you've got a standard set of terms, you've got them prepared in advance, you're really only doing some tweaking at the end, then that really helps all of the parties. And in some cases, not all, if you've got a good relationship with your opponent, you might even talk ahead of the mediation about the sort of terms that are likely to be uncontroversial. And you can get those, in principle, sorted before you even start a mediation. So that when the crunch time comes and you've just got the final few terms to be arguing about, it's unlikely to be an issue hotly disputed, whether or not you include, say, a confidentiality clause or what the recitals to the agreement are. These sorts of things can be sorted out in advance.
But with unrepresented parties, it's very, very important to take them through the agreement and make sure they understand it. And furthermore, to understand it's not just what happened during the mediation, but what's in the agreement itself is confidential. And make sure they clearly understand that. Could save a lot of trouble down the track, I can assure you.
Do you find sometimes that there's a fresh impasse arises between right of reinstatement and judgment in default for the compromise versus judgment in default for the full amount of the claim? I've found that to be a difficulty with some plaintiffs who want a knockout blow. And just wondering whether that's your experience, whether there's logic that you would advance in for either.
What was the first part? I'm sorry, your question.
In the document.
Yes.
Strike out with the right of reinstatement.
Yes.
And then the right to present the settlement with affidavit material and get a judgment in default for the compromise.
Yes, I'll follow.
Whereas plaintiffs more recently seem to be arguing to have the option of the higher amount, of the full amount of their claim.
Yeah.
And I guess you can say, well, let's put a penalty amount in there. If it can.
And then it's arguably void as a penalty, which is what I say. You've got a separate agreement. This sets out the rights of the parties, and you can't apply a penalty for defaulting that agreement. And clients will accept that.
And that's correct. That's correct.
Yeah, I agree with that.
Any other questions from the floor? Because our time is up.
Time's up? Gee, well, we're just having a bit of fun. You should have elaborated if, Gerald, in relation, you've got a psychology degree. Do you ever practice in terms of psychoanalysing the mediators?
Well, I was never a psychoanalyst. It gets me in more trouble than it solves. Yes. I was registered still a registered psychologist until the beginning of last year, because I always contemplated how it might be used in these sorts of processes if I went full time. But I've now stepped right away because of it.
Well, you'd have a field day if you did it with legal practitioners generally, but that'd be good.
Well, just on that note, I'll just say the most difficult person I've ever had in a mediation, and Tony Nolan was in fact my counsel. I looked to the general session. It was a person like you were speaking about before, where they pump up the claim to an unrealistic amount and there aren't the merits. And three co-defendants, defendant one is a solicitor, and really erroneously leading on two other defendants on a hopeless course that not in his case but in their case had risks of bankruptcy. So as a party, I looked to the general session to deliver a sermon to defendant one. Now, a psychology degree did not help me at all because I didn't recognise the personality. I knew it, Mr. Addick, when Tony Nolan, of all people, said to me, he thought I'd gone over the top.
That's getting a bit rich.
Well, ladies and gentlemen, thank you. The next seminar is 26 July. What strikes me about today's session is the theme of understanding and managing the client, and I actually would like a psychology degree because managing clients would be of great assistance. Communication. It is crucial to communicate, and the ever oft-repeated comment, preparation. I mean, failure really requires no preparation at all. You must prepare at the end of the day, because alternative dispute resolution and the Melbourne model is likely to continue and probably grow in Melbourne. We are seeing some signs of some mediations that are not settling, being adjourned to a subsequent occasion with more information being provided. We've started seeing that in the last short period of time, and there are some instances also where inappropriate large disputes with multifaceted issues of co-mediations also developing very slowly to assist the big ticket cases with a multitude disputes. And again, all those themes of communication, empathy, flexibility, preparation, client management and confidentiality, as Michael talked about, are recurring themes. Thank you very much for coming. Thank you for your participation, and look forward to seeing you at the third and final session of this ADJR Greens List series.
And I should have said, in relation to that paper on confidentiality, if anyone would like a copy, they either can give me their email address or give it to Michael Green or Brett, someone on the list. That'd be good, and you can get the secretary to press a few buttons and you'll have it today. It's a comprehensive paper if you're interested.
And thank you particularly to the panel for their wisdom, experience and their time. Thank you very much everyone, and good morning.